And then I'll leave it here. So my apologies to interrupt you, but we're going to give the floor to our keynote speaker. Now is Eric de Brabandere. You have already met him. He is now the director of the Grosso Center for International Law, and he's also the chair. And I forget the name of the chair, so I have it. It's over here. International Dispute Settlement Law at the University of Leiden in the Netherlands. Eric is going to give the keynote speech today, speech, and it is titled Recalibrating Investment Law and Arbitration, Measuring and Adapting to Fluctuating Standards in Investment Law and Arbitration. But before giving the podium to Eric, I would like to thank the BC Law School for organizing this conference, and particularly Frank Garcia, because none of this would be possible without his help. So thank you.
So thanks, Sebastian. Thanks again, Frank and Sebastian, for having invited me to speak here and to give the keynote. And I'm sorry to give you some heavy legal stuff for during your lunch. I'll do my best to be a bit more light in the discussion to help digestion. So I think, to be honest, many of the things that I wanted to say have already been touched upon in various panels, and probably will also be touched upon. So the idea today, what I wanted to say, is look a bit at how do we evaluate investment law and investment arbitration, because we hear many elements on reforms, proposals to strengthen certain elements, to revise certain other elements. I think it's quite interesting to have a look at, well, how do we assess whether investment law arbitration functions as good or bad? This is why I came up with the title, Recalibrating Investment Law and Arbitration. And so based on the title of the presentation, you may expect a sort of hard scientific analysis of investment law and arbitration, which I can assure you it will not be, but I was actually quite interestingly at my high school, a Jesuit school, so I'm very well placed at Boston College, educated to be actually set on a track to be a civil engineer with a lot of maths and physics and chemistry. But at the end I decided for a more exotic field of study, law and then international law. But still, I still have this idea of physics that I think is quite interesting. So I came up with this idea of calibration. And calibration, I think, is quite an interesting term if you look at it compared to balancing, which we often find and we often use, including myself in investment law and arbitration. Balancing is always based on the idea that you have to find a sort of point where two elements are equal or keep each other in balance. And I think maybe for investment law it's probably not, again I use it myself, not always the best element to use when you when you want to evaluate investment law and arbitration, because we're dealing with very different elements in investment law and arbitration. I don't think it's always easy to say that we should find a balance. We should not, for instance, find a balance between the host state and the foreign investor. I think they're very different parties, and I think it's very difficult to find a balance between the two. The same goes for balancing investor rights and investor obligations. From the international law perspective, it's more indeed about investment rights and not investment obligations. So finding a right balance, I think, is not always the good starting point. I'll come back to this also later on. So calibration is more interesting because calibration basically is part of what is called metrology, or the science of measurement, where you basically have a standard and you measure what you have in function of that set standard. Now, this raises the first question, which I will address today, is, well, what is the standard, where do we get it from, and how can we measure investment law in function of that standard? But calibration is also more interesting, I think, because it's also relatively agnostic about what standard should be. And the standard is basically agreed upon, usually on an international or at a domestic level. But it's agnostic. It doesn't say whether you should adapt the standard or not in function of the measurement. Now, I assure you I'm also less agnostic than the colleagues from metrology. So I'll try also and hint maybe at certain directions. So the first question I will address is, of course, what standard do we have? How do we set standards? What standards do we use? And then I'll look at three specific examples of where you see that the standards are really fluctuating and what influences the setting of standards. And the three elements are, one, more substantive investment law, FET, fair and equitable treatment, and expropriation. The second one is the idea to introduce human rights obligations and environmental obligations of foreign investment. The third one relates more to transparency. I'll be a bit brief on this because we discussed already this in detail in the last panel. I think it's an important discussion, the standard, this question of how do you assess, how do you measure investment law and arbitration, because it relates generally to the legitimacy of the system. And it relates to questions of fairness, of governance that Frank also mentioned during the introduction. So one of the objectives of looking at the standard is I think also to say that probably there is no standard. That it depends very much, and Rusty Park also mentioned, it depends very much on how you look at investment law and arbitration, and which objective you see for investment law and arbitration. Now, there are standards that are legal standards. I'll focus on these ones. You, of course, have other standards that are policy-based political standards, which I'll not discuss, but they're, of course, very much present when states sign treaties. Generally, there is a legal influence or an influence from law, but there's also an influence, I think, that's more profound from the specific policy of the political situation of the state. Now, we discussed already in a couple of previous panels the objective of investment law and arbitration. So before I really engage with these three, first something about the idea or the genealogy of investment law and arbitration. Now, it's quite interesting because you have different theories on what investment law really is about. Frank also mentioned protecting capital. I think you have actually a variety of objectives. But if you look at the current regulation and investment treaties, I think you have to concede that the main objective of investment law is probably to promote investment. And the idea, which may sound a bit naive, I'll come back to this, is of course that you sign a treaty with the idea that if you protect investments, you will actually attract investment. That's the original sort of DNA of an investment treaty. And there's of course much that has been written on where investment treaties come from. They originate from friendship, commerce, and navigation treaties, where the idea also of friendship is very much present. The idea of signing treaties with states with which one has a friendly relation, at least at the time of signature of the treaty. It can change over time, of course. And I think the idea of investment treaties that originate from these friendship, commerce, and navigation treaties also reflect this idea of promotion. You find this also very often in the preambles of treaties, where states actually confirm that the main objective is not necessarily to protect investment. If you look at the preamble, it's very often more relating to the idea of promoting, stimulating capital flows between two countries. Now, again, it's a bit naive. Depends very much probably on which side of the negotiation table you are on. If you're on the side of the capital exporting state, the one that actually has more investors investing in foreign economies, probably your interest as a state will be more on the side of the protection rather than the promotion. If you're the host state, very often you will, of course, be more interested in the promotion of the investment rather than extending protection. And some states, China was mentioned also in 2 panels ago, are both capital importing and capital exporting states. The US is also a capital importing and exporting states. So it mainly implies that the naivety of saying that it's only about promotion is probably a bit more complex. But I still think that's the main idea, and the reason why, for instance, the ICSID Convention entered into force was because African states signed the ICSID Convention. 19 out of the 20 ratifications necessary were African states. Why did they sign the ICSID Convention? Because at that time they were convinced, either themselves or by the World Bank, that they had to sign the ICSID Convention to attract foreign investment. That's also why they massively signed investment agreements. Now, the question then is how do we set the standards and what kind of influences do we see? This is, of course, a very tricky subject. I also mentioned first, I'll focus on the legal standards. Now, investment law has relatively ancient origins. The protection of aliens is a relatively old set of rules in international law, and the international minimum standard, protection from expropriation without compensation, is actually very old in international law. So there is a part where you can see, even now in investment treaties and the US model BITs over the past years, the Canadian ones are examples of this, where the standard is actually tested through the customary norm, the customary norm of what happened in the late 1800s, early 1900s. It's not very helpful because tribunals are very creative in establishing the current customary norm, which basically means that if you look at it from a purely legal perspective, the only standards you can use to evaluate whether investment law or arbitration is good or bad, in the sense that it meets certain requirements, is basically the standards set by the states themselves in the treaty, which is a bit odd and at the same time circular, because you will have to, or you will try to assess whether what states do is right or wrong, good or bad, in function of what the states themselves have done in the past or other states do, which makes it a bit complex. To add to this, you have, of course, other regimes of international law that are very present in the whole discussion. We mentioned already the World Trade Organization, and you see that more states are, for instance, including Article 20 of the GATT exceptions in their investment agreements. You also have people involved in investment law and arbitration that are more WTO trade law specialists and actually have their background, this is of course a more sociological perspective, their background that influences how investment law and arbitration is drafted, not only in practice, but also, not only in practice, I mean in the arbitral practice, but also in terms of treaty making. If you look at the European Commission, that's negotiating or negotiated with Canada, the CETA, with the US, the TTIP, and is negotiating similar treaties or starting to negotiate certain treaties, such treaties with China, Thailand, Cambodia, Singapore, Indonesia. The people originally in charge of negotiations were staff members of what they call the DG Trade, the Director General of Trade, who only had expertise in the World Trade Organization, dispute settlement. And you see, therefore, that much of the investment court system is modeled on, not to say certain points slightly copy-pasted, from what is happening at the World Trade Organization. Because from their perspective, from the perspective of the European Commission, the standard is actually not the investment arbitration that we know, but rather what happens at the World Trade Organization. There are other examples. The human rights regime is, of course, fundamental. I'll come back to this. International environmental law. Again, you can have standards from environmental law, from human rights law, that are very different in nature than international investment law, and they actually also heavily influence what states do in their investment treaties and how one looks at international investment law. If you look at a dispute settlement perspective, there also you have different regimes, different ways of looking at arbitration. I mentioned already the WTO perspective, the GATT perspective. But then you have, of course, the models of commercial arbitration, the hybrid idea, namely investment arbitration is not private nor public, it's a bit of both. And then another theory, which I'm more defending in general, is the idea that it's more a general public international law dispute settlement mechanism. And then you also have the public law analogies that's been defended by several scholars, where they basically investment arbitration, including by Gus van Harten, who defended the idea that investment arbitration is actually more, if you look at the type of disputes, more a public law dispute settlement system. And so therefore you should adapt investment arbitration to the public law model, to what happens in domestic legal systems. So throughout my three examples, I'll try also briefly touch upon all these elements to see how we can actually evaluate a bit of a bad word maybe, but critically assess the contemporary investment law and arbitration regime. So the first area is the redefinitions of fair and equitable treatment and indirect expropriation. I mean, there's this whole set of new treaties that have fundamentally changed how investment law regulates or investment law protects foreign investors through fair and equitable treatment and indirect expropriation. Now, I'll not spend much time on this. It was also discussed in the first panel, but we all know that fair and equitable treatment is a very interesting standard. It's probably the most important standard in practice, together with indirect expropriation. But it has one fundamental flaw, is that no one knows what it is. At least if you look at treaties, they have usually minimalist definitions, which leaves it what we call tribunals, leaves to tribunals to interpret fair and equitable treatment in function of a more semantic approach. I mean, what does it mean to have fair and equitable treatment? It's more of a dictionary type approach. And you see a couple of treaties, notably those that have been signed by the European Union, but also the US model BIT and the Canadian model FIPA has also been very important in this respect. The Indian model BIT has also interesting reformulations. The Norwegian model BIT of 2016 is also quite interesting one that one has tendency to forget. And they're actually resetting the standard. It's a complete overhaul of what we formerly knew as fair and equitable treatment. Now you have basically very often a relatively short list of what fair and equitable treatment really is, and you have certain general provisions that conform to what was generally seen as part of fair and equitable treatment, such as protection from arbitrariness. But what is more important is what is left out. You very often have now in those treaties provisions which exclude legitimate expectations as part of fair and equitable treatment, and which also exclude the idea of a legal stability, the possibility for the state to make changes to its law. This also is very often coupled to an explicit recognition of the right to regulate in investment treaties, especially those signed by the European Commission. Now again, where does this come from? Here again, I'm relatively voluntarist, maybe you will say, in how one should look at fair and equitable treatment. I don't think there is one single approach to fair and equitable treatment. I don't think you can actually say that a broad or restricted fair and equitable treatment is actually better than the other. It depends very much on what you want as a state to protect and what your idea objective is of international investment protection. But here you see nonetheless influences of public law, administrative law. You also see influences of the World Trade Organization if you look at certain provisions in treaties signed by the European Commission. And the same goes for indirect expropriation. We have seen also over the past years reformulations of indirect expropriations, where specifically measures relating to the public interest to protect the health, safety of workers, for instance, were excluded from being considered as an act that would result in indirect expropriation. This is also heavily influenced not by international law, because international law doesn't say anything except for what the states say themselves. It's heavily influenced by doctrines of takings. For instance, in domestic jurisdictions, the United States, for instance, has been very important in this respect, but also in the European Union, the German perspective on direct expropriation has been very important. The European Court of Human Rights treatment of the protection of the right to property in the second protocol to the European Convention, and exceptions to this that have been usually assessed by referring to the principle of proportionality, and we have the specialist of principle of proportionality investment law here. Sebastian has written extensively on this. This is a standard that was imported from human rights decisions of the European Court of Human Rights. A second example is the issue of the human rights obligations of foreign investors. Now, there has been since many years a lot of discussion on the obligations of investors. PITs and other investment agreements, as we know, are unilateral despite their names. Unilateral in the sense that they have one objective, that is to promote investment by protecting investors. They actually do not usually contain any rights for states in the sense of corresponding obligations of foreign investors. This has been highly criticized over the past 5 to 10 years in scholarship mainly, but also as a result of certain decisions that have been rendered. Here also the question is, well, what do you use as a standard? What kind of principles can you import from other regimes? And you see that here the discussion was heavily influenced by human rights lawyers and environmental lawyers that have tried to incorporate environmental obligations, human rights obligations of foreign investors in investment treaties. I think it's quite an interesting exercise, but here also you see the limits of how to set the standards. Because if you look at human rights law, I think, and this is a bit controversial of course, I think it's really impossible to say outright that foreign investors are bound by international human rights law. There is no single international legal instrument that actually contains obligations binding on the foreign investors, corporations directly under general international law. You always have to pass through the domestic legal level, in the sense that those international human rights obligations that are incorporated in the domestic legal system, it's valid also for environmental law, are actually directly applicable to the foreign investors. There's an interesting case in this respect, Brabandere versus Argentina. It's one of the first cases where the state was actually, in that case Argentina, was allowed to bring a counter-claim against the investor based on violations of the right to water, the right of access to water, which was, according to Argentina, included in the concession agreement on water distribution that was signed with Brabandere. The tribunal engaged in a whole discussion on whether indeed human rights obligations are binding on the corporation directly. You have to read the case, it's quite interesting. I have much disagreement with how the tribunal treated the issue because they first started with a whole discussion on the subjectivity of corporations. Are corporations subjects of international law, saying that at the end it doesn't matter where they are subjects, but that there is nonetheless an indication that they may be subject to international human rights law, to conclude that at the end the counterclaim of Argentina was not based on international law but on domestic Argentinian law, so that the whole discussion they just had was basically completely irrelevant. But the idea here again is, why did the tribunal do this? The main idea was to again change the standard, to modify what and how investment arbitral tribunals and also states when signing treaties look at these questions. And you see this very well in one comment that Andreas Bücher, who was the presiding arbitrator, professor from, former professor at Geneva University, he replied to a comment on EGIL Talk being a blog post of the European Journal of International Law, where someone criticized the decision, and he actually replied, you have to look it up, and he said, I would have expected more support from the international community to this decision. Which is quite an interesting statement. First, you can ask the question whether it's up to the presiding arbitrator to actually comment on a comment criticizing the decision, but I leave it to someone else to decide this. But you see that the reason why this was actually done is a sort of more legislative, standard-setting behavior of international arbitrators, which from Andreas Bücher also is quite interesting because he's actually a private international law commercial arbitration specialist and not necessarily a public international law specialist. But you see nonetheless that the whole discussion has prompted not only arbitral tribunals to reflect on this, but also new international investment treaties. And there's one very important one. Again, I'm referring to Africa. You have a draft Pan-African Investment Code, which is it's a final draft. It's not yet adopted, but it's a very interesting treaty. It's basically a Pan-African investment treaty in which they follow for certain issues what has been already said and done by Europe, the US, Norway, India, etc. But they have at least 6 provisions dealing with human rights and other obligations of corporations. Some of them relate to corporate social responsibility, the need to respect corporate social responsibility codes, business ethics and human rights, and then you have also principles that should govern compliance by investors with business ethics and human rights, and these are support and respect the protection of international recognized human rights. Now, this is all quite interesting. You'll ask, of course, why do you have this? Well, one main reason, this is to allow more easily counterclaims of the states against foreign investors. You also have this in a couple of other new treaties, such as the Morocco-Nigeria BIT of December 2016. The third element, and then I'll conclude, is the question of transparency. Again, I'll be very brief on this because we all know that there is now transparency, especially now that SIAC, Singapore International Arbitration Center, has adopted a new set of rules for investment arbitration, including transparency. The SCC, Stockholm Chamber of Commerce, also added a whole section on investment arbitration in its arbitration rules. ICSID did it already in 2006. The UNCITRAL did it already also in 2014, and it was included in the Mauritius Convention that entered into force last week, if I remember well. Now, this transparency is also quite interesting, and I remember very well a discussion from a colleague who was representing his state at the UNCITRAL discussions on transparency, and he came to me in 2014 with the great news that they finally had adopted rules on transparency. It's groundbreaking, fantastic, new development. I told him, but ICSID did it already in 2006. I mean, you're 8 years late compared to ICSID. And then he told me, yes, but you have to not assess this from your perspective, but from my perspective, which is international commercial arbitration. This is really groundbreaking because we actually managed in the UNCITRAL to have special rules that, moreover, are only valid for treaty-based arbitrations, but commercial arbitrators actually modifying the standards of secrecy proceedings to transparency. Well, as I explained, I told him that I thought it was quite natural to have such development and that they're actually lagging behind what has actually been done in 2006 at ICSID and following tribunals that had already decided similar issues before, including under the UNCITRAL arbitration rules. So to conclude, sorry, it took a bit more time than expected, I think. The whole idea, I left out a couple of things because many things were already discussed. I think my main point was to say that, well, it's a very interesting exercise what we're doing today, is to look at investment law and arbitration. But there is one question that still remains, is that how do you look at it? And from what perspective do you look at investment law and arbitration? And we all have various ideas. We are all in favor of, I'm a big fan of transparency, but you have to keep in mind, I think, that the standard setting in investment law arbitration is not as easy as it may seem. It's influenced heavily by people drafting investment agreements. It's influenced by geography, it's politics, policy of states, but from a legal perspective also, the investment law regime now doesn't help very much because you, again, investigate, evaluate the practice of states based on their own practice, which is a very difficult exercise. Other rules of international law leave you with usually not much information. A couple of exceptions: human rights, environmental law, I think, is quite interesting, these developments. So it's, yeah, when I was rethinking everything I read, I wrote down, I think it looks a bit like an anarchist perspective on investment law and arbitration, which is basically that you can do whatever you want. But there is a part of truth in this. I think states can do whatever they want. There is a whole part of voluntarist, pure voluntarist approach to how investment law and arbitration is regulated. And the perspectives we have are also, again, heavily influenced by our own background, the various fields we are specialists in, and our previous expertise and practice in these fields. Thank you.
Well, thank you, Eric. And now if you have questions, if you want to engage in some kind of commentaries, observations, or anything. Over there, Enrique.
Well, thank you very much for the presentation. I thought it was very interesting, but I wonder if you think that is odd that we have this system of international investment law, which is already fairly established. It's already issuing, the arbitral tribunals are already issuing awards. And then at this point, we take so many steps back and we say, well, what is this system really for? How should we even think of it? what are its bases? It seems like these sort of questions, it just seems like an odd development for an international structure of this caliber. So I wonder, you explained a little bit at the end of your presentation, but I wonder if you can expand on what do you think this is, that it is evolving in this fashion.
I don't know, maybe we can have 3 questions and then give Eric the opportunity to answer them.
So my question, in a way, builds on Enrique's question, which is, and again, you touched on this right at the end of your remarks, but I think, insofar as you are, I think, correctly characterizing this as a somewhat anarchic system, I wanted to ask, in what sense are you describing it as an anarchic system from a purely empirical or descriptive point of view? And in what way are you actually suggesting that there are virtues in it remaining an anarchic system rather than a more centralized, coherent, hierarchical system? I think Gus Pauline's written about this too. He wrote about investment law from the point of view of chaos theory. And I think I might be somehow instinctively European, though I don't know why, in that I'm wanting to make more bureaucracies. But I do wonder how strongly you're advocating this sort of present disaggregated model of development, or how much are you saying let's sort of play the game that we have?
Thank you. Don't you think that the use of the general principle of administrative law as a source of international law, according to Article 38 of the Study of the International Court of Justice, can help to calibrate the investment law, particularly taking into consideration that investment law is not only deals with the promotion of direct investment, but also with the promotion of the rule of law in the global space. Taking, for example, the case gold reserves versus Venezuela, in which the fair and equitable treatment was interpreted through the lens of the general principle of administrative law.
Thank you so much for those wonderful remarks. Just a quick doctrinal clarification, if you want to do something. Do you think corporations can be subjects of international law by either contract or treaty law, or you are just descriptively arguing that doesn't happen? I mean, I just want to make sure that I'm just curious about that, the doctrinal point that you're making. Thank you.
Yeah. So maybe I'll start with the last question. I was a bit ambiguous on this. I fully agree. I think the whole question of whether a subject is completely irrelevant, actually. I think what counts is whether you have obligation or not. I think it's very easy to simply say at a certain point, well, international corporations should all respect international law. You can do this. It happened in international criminal law, where they said that individuals can violate international law. So you can actually do this relatively. Easy is a big word. You'll have to find the right instrument, the right way, of course, to come to the instrument. But I don't think the whole question of subjectivity is actually very important. That's why I'm also a bit reluctant to look at these decisions of arbitral tribunals saying, well, we'll look at the subjects. It's all a bit irrelevant, I think. And to be honest, the whole debate on whether states, non-state actors, corporations are subjects or not is a debate of the 90s almost. So I think now we have to look at basically where you have these obligations or not. And you can put this actually in an investment treaty. It's a very simple, again, simple exercise, if you want. So I'm relatively open to all this. The thing is that it's not there yet. So that's why I have problems in people and tribunals saying that this is what is out there, because it's not. And you can still do whatever you want, but as an arbitral tribunal, I think you have to be a bit more careful than when you write as a scholar, saying that it's out there. You can't justify, I think, the same if you're an arbitral tribunal. So I'll take maybe two questions at the same time because they're a bit related. You're absolutely right. Here also I was maybe a bit ambiguous. I sort of have a colleague and friend who usually says, I'm not saying what it is what it is. Which is also a good way to get out of the whole discussion. I think it's based a bit on empirical analysis, but I think it has also some normative value and virtue. Because I can difficultly imagine another system where you would have this standard setting by someone else. I don't see how you could actually have this. It was tried in the past, and it doesn't happen simply because states are when they sign investment treaties, have very different ideas of what an investment treaty really is for, and it relates a bit to your question. You have this whole discussion indeed on investment treaties being good for the respect of the rule of law, promoting good governance in states. I think it's a bit of I may sound here like a critical legal scholar, but I think it's a very good excuse to justify investment treaties. A state which is typically capital exporting is interested, if you look at the Netherlands, for instance, and I work in the Netherlands, but I'm Belgian, they have one interest is attracting foreign companies to their territory for tax purposes. That's why they have very advantageous tax legislation. And then they also have investment treaties, a whole web of investment treaties that are very beneficial to investment foreign investors with broad definitions of investors. And to be honest, I don't think the idea of promoting the rule of law or good governance is really one of the most important aspects of the policy of the Dutch government. I think it's, again, a bit of a post hoc justification or excuse for signing investment treaties and agreements. On your question of principles of international law, yeah, I sound a bit like a skeptical. I'm always skeptical about general principles of law, to be honest. It was included by a Belgian Baron Decamps at that time in the negotiations of the PCIJ statute. To basically have a way out if you can't decide anything, you say, okay, but it's a general principle. So that's my general stance on general principles. More on the administrative law side, I think there's quite value. Stefan Schill is doing a lot of work, of course, on public law and comparative constitutional law. I think it's an interesting exercise to give more substance, meaning, interpretation of certain investment provisions, but I don't think it's exactly the same system because, again, the standards you're testing against are very different. The first difference lies in the fact that here you're dealing with acts of states in the international law context, while in administrative law, the types of acts you're testing and the standards against which you're testing this are very different. They're very state-dependent, of course, on the constitution and the administrative law requirements. But there is, of course, a cross-fertilization and influence of both. And I think from that perspective, it's an interesting exercise, but you can't transpose the public law, administrative law system to the international law level. Also for questions of compensation, for instance, the whole principle of administrative law and constitutional law usually is to retract an act, not to give financial compensation for it. This is something you can difficultly imagine in investment law in any type of situation.
Thank you, Eric, for your remarks. Yes, I just want to think a little bit different in the approach of this recalibration process that you described to us. And is a recalibration or just is coming back or going back in history? And I will explain why. And it's coming back in history because all the provisions that now we see in the European proposal and in the CETA and TPP explaining what the standards means is that it's an interpretation of what the standards should mean, more or less. You can see this in the overall thing. And why this happened? And where is the background? The background is in something that you know very well, which is investment law is public international law. And international law is based and rooted in power and sovereignty, these two concepts. And when you talk about power and sovereignty, well, policy space, if you wanted to put it in that technical word of investment, in the investment field, then you just find something else. And I would like to know what you think about this. That the current treaties that we have, the ones that we signed in the 90s and after the 90s, this first generation of VITs, had the same provisions, but from my point of view, the states never lose their sovereignty. Because this is public law, again, public international law. And that's why I say this is just coming back in history. And these new treaties, generation of treaties, are just interpretations of what should be read by arbitrators. Okay.
Thanks for a very thought-provoking presentation. I want to ask one question, and then within that, probably two further sub-questions. The main question is, given your view, and probably that's what it is, of the chaos and anarchist situation at the moment, do you think the time is ripe for a global kind of multilateral investment instrument, which kind of will unify the law? That's the first question. And the second question then is, if you think so, what are the prospects? And lastly, would you advocate for inclusion of provisions that will obligate investors to certain substantive issues such as human rights, environment, and other things to which they could be, which could be enforced against them?
Well, actually, my question ties to the previous question, and is if you could reflect a little bit more on your claim that there are limits in relation to how to set standards for obligations of investors, because when you were replying to the question whether they are subject to international law, you say it's irrelevant. We just can achieve what we want by creating such obligations. Now we see this happening in some treaties. Of course, the language of the treaty, like I have the Indian model bit in front of me, it says investors and their enterprise within its territory of each party shall endeavor to voluntarily incorporate internationally recognized standards. So you're saying, well, there are not these standards, but it seems reference to that. So if you could reflect on what would be the implications of this general trend to incorporate these obligations, even if in somewhat ambiguous terms.
Okay, thanks. Very, very interesting questions. I'll start also in reverse order, if you don't mind. Alessandro, you have different formulations, and you're absolutely right. The Indian model BIT is not the Pan-African Investment Code, and not many other treaties. The vast majority of the treaties so far have only really indirect, generic references to indeed corporations should respect corporate social responsibility standards, should endeavor to, states will try to do their best to, blah, 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 which is not very helpful in practice. I mean, it may serve as sort of interpretative tool to provisions, to interpret provisions like fair and equitable treatment. I said it's very difficult to incorporate standards because if you speak to human rights lawyers, they will consider it to be very strange to have an investment law regime which doesn't contain any corresponding obligations of foreign investors. And maybe rightly so, because you indeed have rights that are relatively extensive granted to foreign investors. But the question is, here also it's very often presented as a question of balance, and I think the balance here is not very easily achieved because the human rights obligations of the investors are very different in nature than the rights you give them. So I think it's very, very difficult to imagine such a situation and find treaties nowadays where there is this balance that has been found between the obligations of foreign investors and the rights of foreign investors. There is a tendency, I think the Pan-African Investment Code is probably the best model so far that was negotiated on, that has been drafted in this respect. But yeah, it depends again on how you formulate precisely this obligation. And states are not yet willing to have a full obligation. Even the Pan-African Investment Code, if you look, they basically say that this article can be used as a defense or as a counterclaim against the state, which actually means that you can use it only as a counterclaim, but not to initiate a claim, for instance. This would actually be very interesting to have a claim on behalf of the host state for violations of the obligations. But we're not there yet because, again, the standard that you use, the human rights standard of the obligations of states towards their nationals cannot so easily be transposed to corporations. First of all, because there are certain obligations that can only be respected through the state, which means that it's very difficult to imagine corporations even take the right to water, for instance. That was at stake in Urbaser versus Argentina. The whole discussion was therefore very interesting because the question is, can you actually say that Urbaser, a company in water distribution, has the obligation to ensure the right to water of the Argentinian population? It's very difficult to, this actually means that every company that invests in the water distribution system has actually an obligation to respect the International Covenant on Economic, Social and Cultural Rights and to implement the obligation of the state in place of the state. So it's, the conceptual leap you make is not so easily done for all human rights. For environmental obligations, I think it's probably a bit more easy, more interesting, but for especially those from the International Covenant on Economic, Social and Cultural Rights, it's a bit more difficult because these obligations are also framed in different terms than the ICCPR, which has more direct. But there also you can question whether you can, as a corporation, be responsible for violations of the right to free and fair elections, for instance. There may be contribution to that violation, but is it really the responsibility of the corporation only? So you have to think this carefully. That was my main point, and not so easily simply say, well, we'll apply exactly the same standards from human rights. You have to find a way in which to draft this, and it's not easy. That was my main point. So Emmanuel, yeah, I'm really skeptical about the global investment law treaty. I don't see it happening very soon. And simply because even if you look at the EU, within the EU, member states already disagree on how to draft CETA. And we discussed it yesterday over dinner. The prospects of the treaty being ratified will take years. And this is only Europe. It doesn't even count other regions, Africa. Asia, I can assure you that states like Indonesia and Singapore have very different views on investment law also, because Indonesia clearly wants to avoid claims and Singapore wants to attract as a state foreign investment, also as an arbitration center. So I think it's very difficult to come up with a single definition. And your second one, how would it look like? Well, if I'm the tribunal in Guinea-Bissau versus Senegal, I would say, because I answered in the negative the first question, I'll not answer the second question. I don't know, to be honest. I think it's very likely that if you will have this once, you will have this emphasis, I think, on the obligations of foreign investors. You see it nonetheless as a tendency. CETA, TTIP are a bit the exceptions, I think. Also, I think, to be honest, because the European Commission was not creative enough and didn't have the background to include these kind of things in the discussions. Then, Jose, yeah, the first, I had a whole discussion always with my former colleague, and we were sharing offices, about whether evolutions in investment law or in arbitration are actually conservative or progressive in nature. Because in a certain way, whatever is progressive is very often conservative at the same time, because you go back to what was the case a couple of years ago, a couple of years or decades before. Because you're always referring back to the past. I think it's a bit of a natural tendency for states because they have a tendency to react against evolutions by curbing the evolution and getting back to their original intention, or at least what they think was their original intention. So they evolve by going back and completely getting rid of the evolution and getting back to a certain, in this case, idea of a sort of international minimum standard and relatively restrictive provision on expropriation. I agree on your point on sovereignty. I actually don't like the discussion of sovereignty because we're indeed dealing with treaties. I don't think there's any renunciation of sovereignty of states when they sign a treaty. Signing treaties, in the famous words of the PCIJ, is, in the Wimbledon case, signing a treaty is an exercise of sovereignty, it's not a restriction of sovereignty. And it's the same for investment treaties. They don't restrict their sovereignty, they just accept that their exercise of sovereignty can actually be tested against certain standards. So I think this whole discussion on sovereignty is interesting, but you have to, again, place it in the right perspective. It's not about restrictions to sovereignty, but maybe restrictions to the exercise of jurisdiction that is derived from sovereignty, for instance. But you're right, power is, of course, fundamental, and I do see that this is shifting a bit, like states like Indonesia, and I have a research project with the university and also with the ministries over there. States like Indonesia are heavily reacting against the current regime. They denounce many investment treaties, notably the ones with the Netherlands. And they're actually planning to renegotiate entirely. So a bit different than South Africa. They're actually going to establish, and they have already established, a new model BIT. But you still have to, again, change the mindset you're in. States like Indonesia still are in this idea of, well, we have to sign a treaty to attract foreign investment. But the sort of power game you're involved in when you negotiate investment treaties is something new for many states. And it's not only capital importing states. If Belgium has signed treaties without knowing what they have signed. This was signed by the Ministry of Finance because they always signed BITs coupled with double taxation treaties, which was a competence of the Ministry of Finance. And the guys from the Ministry of Finance had no idea of what the BIT was. So that's why you have different models of investment treaties. The one with Colombia, for instance, is very far-reaching. On questions of environmental protection and these kind of things, which you don't find in other treaties. So it's probably a mind shift for states as well in this respect. I hope it answers your question. I know I'm a bit still ambiguous, but for
the first one, is yes or no? For the first one.
if we're coming back to the history, to the past, yeah, I think we are, yeah, yeah.
Well, thank you, Eric, for a very interesting keynote address then. And I think we have 5 minutes before starting the panel number 3, so we can arrange the table.